Okay, so hello everyone, and welcome back to the Freeman Spogli Institute Israel Studies Winter Quarter webinar series. My name is Amichai Magen, and I'm the visiting fellow in Israel Studies here at FSI. And this winter, Professor Larry Diamond and I are bringing you this new series of FSI webinars exploring various aspects of contemporary Israeli politics, constitutionalism, society, and security challenges. Our webinars so far this winter have, understandably, focused on the causes and implications of the October 7th Hamas terrorist attack and the subsequent war. But of course, that is not all that has been happening in Israel over the past several months. The shock of the war has undoubtedly changed Israeli society and politics, but it has not stopped or even temporarily suspended the social, political, and constitutional struggles that gripped the country before October 7th. In fact, none of the burning questions about Israel as a polity and constitutional order, questions which deeply divide Israelis and that brought hundreds of thousands of protesters into the streets on a weekly basis in the 9 months preceding the October 7th attack, none of these questions have gone away. Legal proceedings in Benjamin Netanyahu's trial on charges of bribery, fraud, and breach of trust resumed in early December after a 2-month pause. And constitutional politics and constitutional decision-making also continues in the midst of war. Just 2 days ago, for example, the Israeli Supreme Court dismissed a petition filed by a right-wing NGO against the committee responsible for judicial appointments in Israel, in a move clearly designed to discredit the current composition of the committee and to garner political support for the Netanyahu government's plan to ensure executive domination of judicial appointments in the country. The petitioners claimed that the 3 judges who are members of the committee were tainted by conflict of interest and so could not be involved in judicial appointments. The petition was dismissed, but its filing represents a stark reminder that Minister of Justice Yariv Levin's plan to achieve executive dominance over judicial appointments remains intact. The Supreme Court has also pushed back against attempts to curtail its powers of judicial oversight. On January 1st, 2024, the court issued a landmark ruling in what Israelis called the reasonableness cause of action case. After the Netanyahu coalition government passed controversial legislation in July 2023, preventing Israel's courts from exercising judicial oversight of government and ministerial decisions on the grounds of reasonableness, a full bench of Supreme Court of 15 justices reviewed the legislation and reached 2 main findings. First, in a majority ruling, supported by 12 of the 15 justices, the court ruled that it has the power to perform judicial review of basic laws and to intervene in exceptional and extreme cases in which the legislature, the Knesset, exceeds its constituent powers. And secondly, the court decided by a bare majority of 8 justices to 7 to actually strike down the amendment to the basic law, the judiciary, the means by which the Knesset sought to deny the judiciary in Israel the power to review government and ministerial decisions on the grounds of reasonableness. The ruling marked the first time in Israel's history that the Supreme Court had not only confirmed its competence to strike down a basic law, legislation which carries constitutional status, but actually struck down a provision of a basic law that it deemed to be unconstitutional. In making the ruling, the court invoked 2 constitutional doctrines in particular. One is the notion that certain constitutional amendments can be deemed unconstitutional. And the second has been called the prohibition on abusive constitutionalism, the notion that even the legislature, the sovereign embodiment of the people, is prohibited from violating, in its legislation, certain core principles of democratic order that are absolutely fundamental to that order. Supporters of the court's decision see it as necessary and the court as the last bastion capable of checking unbridled executive power and maintaining the separation of powers and the rule of law in Israel. Opponents of the decision make different arguments, but essentially view the court as having exceeded its mandate. Yariv Levin's reaction to the ruling was, and I quote in translation, "In practice, the judges have taken for themselves all the powers that in a democracy are meant to be shared in a balanced way between the three branches of government, a situation in which it is impossible to legislate even a basic law or to make any decision in the Knesset or the government without the consent of the Supreme Court judges, deprives millions of citizens of their vote and denies them their basic right to equal participation in decision-making." End of quote. Levin also added on the same occasion that the court's ruling will, and I quote, "will not weaken our hands," suggesting that he intends to return to his legislative agenda of weakening the legal establishment in Israel once the current war is over. These tensions between the executive and judicial branches are not entirely alien to Americans, although the legal, cultural, and political contexts are, of course, very, very different. To make sense of all of this, we are delighted to be joined today by one of Israel's most brilliant and respected legal scholars and rising public figures, Professor Yaniv Roznai. Yaniv, who is a dear friend and colleague, is an associate professor and vice dean at the Harry Radzyner Law School and co-director of the Rubinstein Center for Constitutional Challenges at Reichman University. He holds a PhD in LLM with distinction from the London School of Economics and an LLB and BA degrees, magna cum laude, in law and government from the IDC Herzliya, which is now Reichman University. Yaniv's scholarship focuses on comparative constitutional law, constitutional theory, and public international law. And he is the author of the book, Unconstitutional Constitutional Amendments, the limit of amendment powers, which was published by Oxford University Press in 2017. Just before welcoming Yaniv, I want to take this opportunity to remember Professor Amnon Rubinstein, who passed away recently and who was a great teacher and mentor to Yaniv and myself, as well as to many others at Reichman University and beyond. And may his memory be a blessing. Yaniv Roznai, welcome. Welcome to the webinar.
Thank you very much, dear Amichai and Larry. Thank you very much for the kind invitation. And thank you, Amichai, for mentioning Amnon Rubinstein. We miss him dearly, so I appreciate these kind words. So yes, thank you very much for the invitation. What I would like to do in this presentation, and I'll soon share some PowerPoint slides, is to give some context and background for what has been happening in Israel in the last year, so we can understand probably the major constitutional crisis Israel has ever faced. So I will talk about abusive constitutionalism and the case of Israel. But before doing so, let me please talk about the crisis of democracy globally, because I think it is in a way related. Amichai, you can see the slides running, right?
Yes, we can. Thank you.
Thank you very much. So as many of us know, the world is experiencing a crisis of democracy where populist governments are eroding the democratic order. And I intentionally use the word erosion because what we see is an incremental process, but one that is ultimately still substantial and can bring about to a real decay in the basic principles of liberal democracy: competitive elections, liberal rights to speech and associations, and the rule of law. And in its peak, this erosion can bring about an overall change in the governing system, including the introduction of authoritarian and anti-democratic elements, as we've seen in places around the world like Hungary, Poland, and Turkey. And it is not just a case because I mentioned this, because in the Israeli story in the last year, there was even a terminological argument whether what the Minister of Justice brought to the public was a reform or a judicial overhaul. And I'll come back to that later on. And what is interesting about this process of democratic erosion is that there are three important elements of this populist constitutional project. And the first one is that we're usually talking about an instrumental and frequent use of legal and constitutional means. This is what David Landau calls abusive constitutionalism. What we see with these populist governments is that they are not acting in an illegal or extra-legal manner with tanks in the streets, but rather they use or abuse legal and constitutional mechanisms. The second element that is important is that usually we're talking about an incremental process made up of many small increments. And this is important because we'll come back to that later on when we'll talk about the derisiveness bill. So usually you have small increments that would undermine democracy, but none of them is really the end of democracy. And the third element is that we're talking about an aggregated process. So when you examine each of these increments, small increments separately, as I've mentioned, it's not the end of democracy, but when you examine this process cumulatively, then the whole is greater than the sum of its parts. So this is usually the story that we see globally. And here I want to come to Israel. If what we see in the world is that now the assassins of democracy use legal, subtle, and gradual means to kill it, in Israel, the ability to do so is easier than in other countries in the world. So basically, my argument in the coming moments is that Israel is a fertile ground for the populist project. So even if what we see in Israel, or have been seeing in Israel in the last few years, is part of the global movement, Israel has particular features, social and institutional, that make it especially vulnerable for the populist project. I'll just say a few words about the social challenges. I won't go deep into them. In Israel, we have various social divides, such as the Jewish and Arab divide, or the ethnic Jewish divide between Jewish Israelis of Ashkenazi or European origins and the Mizrahi Jews. And this divide makes it quite easy for various leaders to go deep with the populist notion of we and them. And perhaps even more importantly, we have various anti-liberal groups who their entire worldview is completely opposed to that of the liberal democratic one. And we can see that, for example, I just gave one here index from the 2019 Israeli Democracy Index. Just look at these numbers, they're amazing. You have 97.7% of the ultra-Orthodox that were asked that they express distrust of the Supreme Court because the court represents this liberal organ of the state. I don't go deep into the social challenges. We can talk about it later in the Q&A because we have social divides everywhere. But I think that in Israel, we have unique institutional features that make it especially vulnerable, or its democracy especially vulnerable. And the first one is the lack of a rigid constitution. So if we look now around the world, we see that the vast majorities of countries in the world have constitutions, formal constitutions. The only exceptions are the UK, New Zealand, and Israel, arguably. Okay, so already we are in a type of institutional disadvantage in terms of constitutional rigidity or flexibility, and we'll come back to that later. But I think more importantly is Israel's extremely weak system of checks and balances. In all the countries around the world, we have various mechanisms that make sure that political power is distributed among different powers, is not centralized with one organ. So for example, we could think of bicameralism, right? Two houses in parliament, where one house can block legislation or at least slow it down. And that house represents different interests, reflects different views. We have presidential systems, where you have a president with executive authorities, but also with veto powers. And then you have this mechanism of checks and balances between the legislator and the president. We have federal systems, and then you have a vertical separation of powers between the central government and the states or provinces. And we have constituencies or a regional element in the elections. And then the various representatives, they reflect other kind of interests, those of the local voters that sent them. So this is another political mechanism that can block central governmental power. And of course, there are supranational organizations such as the EU. So EU law goes automatically into the domestic legal system of those member states, and it is binding upon them. And all those countries, for example, in Europe, that are members of the Council of Europe, they are bound by the European Convention on Human Rights, and they are bound by the decisions of the European Court of Human Rights in Strasbourg. So these are various mechanisms that can limit and distribute political power. Israel is the only democracy in the world without any of these mechanisms that I've just mentioned. So it is the only democracy with no structural internal or external political restrictions on the legislature. And the situation is even worse because the government, basically in the Israeli system, controls our legislature, the Knesset, and can enact basically anything through coalition discipline. So I put here the word trust because when we asked politicians during the previous year, in light of the proposed reform, and I'll get to the reform in a few minutes, what would stop you from undermining core rights, for example? The answer was usually, trust us. Trust us, we are your representatives, you should trust us, instead of trying to build strong mechanisms of checks and balances. Now, I've mentioned that Israel has no formal constitution, but Israel has a series of basic laws that function as our constitution. So normatively speaking, the basic laws carry a constitutional status. They are above ordinary laws. And the court can even conduct strong judicial review. So if there's an ordinary law of the Knesset that violates a basic law, the court can declare it as unconstitutional and void. However, in one important sense, our basic laws are not constitutional, in the sense that they are extremely flexible. They have no rigidity, constitutional rigidity whatsoever. So basic laws in Israel can be amended or enacted by a simple majority in one day. And since 1958, the year in which the first basic law, the Knesset, was enacted, Israel had 140 constitutional changes. Just to give you a perspective for the American audience, in the last decade, Israel had more constitutional changes than the entire US history. So to put things in perspective, and many of these changes were for narrow political interests. Sometimes these were ad hoc or temporary amendments. But this has not always been the case. If you look at the average since 1958, we had an average of 2.15 changes a year. But look what happened in the last 8 years. This number has increased to 4.74 changes a year. This is really dramatic. It means that our legislators have learned the trick, things that they cannot do through ordinary politics because the basic laws limit them. They simply do through abusive constitutions and through the abusive means of changing our basic laws through the constitutional level. There are some more important structural elements. First is that we have an extremely thin Bill of Rights. If you look at world constitutions nowadays, the average Bill of Rights in a constitution is usually 35, and the modern Bills of Rights include about 50 fundamental rights, and the fact that there are more rights protected in the Constitution doesn't necessarily mean that there's better protection of rights, but it means that these rights are beyond the reach of ordinary politics and can get judicial protection through judicial review. In Israel, we have 11 rights that are protected in the basic laws of human rights. Now, it is true that de facto, there are more rights that are being protected by the court because the court has given a broad interpretation to human dignity in a way that includes other unenumerated rights, such as equality or free speech. But these rights do not get an autonomous and independent and explicit protection in our basic laws. I've mentioned earlier that the Israeli court conducts a strong judicial review of legislation, but it has been doing so only implicitly from the basic laws, something like the US. There is no explicit authority in our basic laws of judicial review. And every time the court intervenes with legislation, there are questions of legitimacy, as people say that the court doesn't have that authority of judicial review. And this again goes against the international or global trend. And nowadays we have about 87% of countries in the world that have judicial review, either in the constitution or implicitly. On the other hand, I've mentioned the structural weaknesses of our political structure. But on the other hand, there are also arguments that the Israeli court, and perhaps rightly so, in light of the weaknesses I've just mentioned, is the most activist or perhaps the strongest court in the world. And I've mentioned here a few points. I'll just go very quickly over them. We can talk about them later if you like. So the first thing is that in Israel, everything is justiciable. The Israeli court can deal with everything. Issues of security, of religion and state. There is no single issue that the court, normatively speaking, cannot deal with. It is true that often the court says, these are issues that I will not deal with, but this is only because of its own institutional self-restraint. The second important point is standing. There is extremely broad standing before the court, and any person can go to the court on any matter of constitutional importance, regardless of the question whether that issue touches or violates his or her own personal right or interests. So if Amichai wakes up in the morning, he reads something in the newspaper that he doesn't like, let's say an appointment of someone to being a minister, he can go directly to the High Court of Justice, this is our Supreme Court, and challenge that appointment. The third issue that I've mentioned earlier is that the court also protects rights that are unenumerated, such as equality. And our legislators intentionally did not want equality to be protected in the basic law. Nonetheless, the court, through its broad interpretation of dignity, protects other unenumerated rights, such as equality, free speech, etc. While in the early 1990s, the Israeli parliament has enacted 2 basic laws on human rights that limit the legislative power of the Knesset, the court, through its interpretation, has given supremacy basically to all basic laws, making them our constitution. And this is again quite contentious. It is unclear whether this was the real intention of the legislators in the Knesset. Amichai mentioned reasonableness. This is indeed an important issue because the reasonableness doctrine in administrative review in Israel allows the court to review any administrative decision of any member of the executive. This could be a minister or a bureaucrat or a regulator, and question the reasonableness of that decision, which means in a nutshell, whether that person has considered all relevant considerations and has given them a proper weight. So this is a balancing formula that gives the court extremely wide discretion to intervene in administrative decisions. I've also mentioned that the court has strong judicial review of legislation, although I must say that I believe that the court has been quite restrained in applying its authority to review laws in the last 30 years, since the early 1990s. The Knesset has enacted approximately, grosso modo, 4,000 laws. The court has invalidated 22 until the last decision that I'll come back to that later. And the final issue is judicial review of basic laws. And this is the issue that I'll come back to in 5 minutes. The court has mentioned in various cases that it has the authority not only to review ordinary laws of the parliament, but perhaps in extreme cases, also to review basic laws. And again, basic laws have a constitutional status. So in light of all these arguments against the court, in the last 15 years, there have been various proposals to limit courts' authority. And here we get to the current government and to January last year, January 4th, in which the Minister of Justice, Yariv Levin, in a press conference that was televised, announced his constitutional so-called reform, what I call judicial overhaul, because this was not a mere reform. This was a proposal that would totally create a total overhaul, a really paradigm shift, a revolutionary change of our judicial system. And I'll briefly go over the proposed reform so you can understand what was at stake. The first point was limiting constitutional review. In what way? At least three ways. One, changing the system from a decentralized model, like in the US, where every court can conduct judicial review, to a centralized one in which only the Supreme Court can review laws. Two, the ability of the court to declare a law as unconstitutional would require a supermajority of 12 out of 15 judges. Now, this is something that doesn't exist in the democratic world. I'm familiar with one country, El Salvador, that has something similar. And the third issue is that even if a court declares a law as unconstitutional, and again, you would need a supermajority of all judges to do that, then the Knesset will be able to override that decision and still enact that unconstitutional law through what we call the Canadian-style override clause, Piskat HaHitgabut, and enact that law notwithstanding the decision of the court. And this would only require 61 Knesset members out of 120. It is a majority, but it's not very difficult because basically every coalition has 61 Knesset members. And the final point of limiting constitutional review was removing courts' authority to review basic laws. But again, remember, this came without any proposed change to the manner by which basic laws are enacted. So in theory, 2 Knesset members versus 1 would be able to enact an extremely problematic law and shield it from judicial review simply by giving it the title basic law. And that would be the end of it. The next proposal was to change the composition of the Judicial Selection Committee that Amichai mentioned earlier. Nowadays, the selection committee is composed of judges, of ministers, of Knesset members, and of members of the Israeli bar. It's a committee composed of 9 members, and you need a supermajority of 7 out of 9 to appoint someone to the Supreme Court. So basically, you need to reach an agreement between the political actors and the judicial actors. The proposed change was that the coalition alone would be able to appoint judges, but not only to the Supreme Court, but basically to all courts in Israel. The implication would be a total politicization of the judiciary and a total capture of the coalition, of the court of the judiciary by the coalition. The next proposed change was to change the role and status of governmental legal advisors. So now in Israel is quite unique in that respect. Legal advisors to the government in Israel, they are independent and they are subordinated professionally to the Attorney General, and their legal advice is binding upon the government. And if the government would not abide by a legal advice of the legal advisor, then the Attorney General perhaps will not defend that decision in court. And the proposed change was to make these appointments political appointments so that each minister can bring his or her own legal advisor, and that their legal advice would no longer be binding, but a mere advice. And the final proposal was to remove all courts' authority to review the reasonableness of the decision of ministers, the prime minister, or the government. And Yariv Levin, Minister Yariv Levin, when he proposed this so-called reform, he also said that this is only the first dish, that this is only the first proposal that will be followed by another group of packages of reform to the judicial system. Now, if you look at these proposals, even if you can justify part of them or perhaps even each of them separately, together, the implication was clear. This would turn the Israeli government to an unlimited government with absolute powers and no checks on its powers. An interesting feature that alludes to the title of this presentation is that the government was abusing constitutional borrowing, as we now say in the literature, because the government was justifying its actions by looking at other countries. And the argument went something like that. They said, look at the US. In the US, we have a political appointment of Supreme Court judges. What, the US is not a democracy? Well, look at the override clause. The override clause exists in Finland and in Canada. What, Finland and Canada, they are not democracies? We simply want to do the same as they have. And look at the UK. Legal advisors, their advice is not binding upon the government. So what, the UK is not a democratic country? And this is what Professor Kim Lane-Shepperly calls the Frankenstate. What the government was doing, the government was abusing constitutional borrowing, taking from other countries only those elements that would give the government powers and that would undermine the judicial supervision and fundamental rights, without taking into account the entire framework, institutional framework, social framework. So I'm happy, at a certain point, I told the government, look, you're talking about different countries around the world. I'm happy that you can pick any of them, but give us the entire package. You want to be like Canada, that is fine. But then you need also to adopt a formal Bill of Rights and a rigid constitution and a federal system. And likewise with the US, you want political appointments of judges, that is fine. But you need a separation between state and church so that judges cannot apply religious law. And you need to have a federal system with a rigid Bill of Rights and a rigid constitution. This was an important element within the governmental reform. And as you've probably seen throughout the year, this reform caused a huge, unprecedented protest movement, where you had every week thousands of people going out to the streets against the reform. And various sectors in the society, including the law professors and lawyers and economics, have joined the protest. And I think an important point in time was, again, in January, where the president of the Supreme Court, the former president now, Esther Hayut, gave an important speech in a conference, in the annual conference of the Israeli Public Law Association, in which she talked about this so-called reform, and she said this would completely undermine the core values of the state as a democratic country. And this phrase is important for reasons that you'll see in a second. I won't go on entirely what happened throughout the year. What we had political negotiations between the coalition and the opposition under the auspice of the president's office. And the president of the state himself proposed a constitutional reform in mid-March. And then the political actors went into deliberations from end of March until end of June. But these negotiations did not succeed. And once they failed, the government changed its tactic. From a big package that it tried to enact very quickly, what we call the Hungarian Blitz, the government moved to the Polish salami, in which the government says, you know what, we will not enact this entire package now. We will start piece by piece. We'll start now with the reasonableness amendment. So that amendment that would remove the ability of courts to review the reasonableness decision of administrators. And then we'll move on to the legal advisors and changing the composition of the court, etc. And indeed, as Amichai mentioned in July, amendment number 3 to Basic Law of the Judiciary was enacted. And that amendment, as Amichai mentioned, completely removed any court's authority to review the reasonableness of the decisions of the government or the ministers or the prime minister. And this was enacted in 3 weeks in Parliament. And it was the vote was a complete divide between opposition and coalition. The opposition left the House in the 3rd reading, and the coalition supported that bill in its entirety. And what's important to mention is that, again, in this amendment, the coalition opted for the most extreme version, There were multiple versions and formulas proposed throughout the legislative process in these 3 weeks. They rejected all of them. And basically, the proposal was enacted almost exactly the same as it was enacted as it entered the process. Actually, there were 2 changes that only made it worse. One of them was the elaboration and making sure the clarification, to be more precise, that decisions include also appointments and removal of office. And this is important because the fear was that this amendment will be used to get rid of the Attorney General, for example, or various gatekeepers. And the second change was to say that a decision includes also a decision of a minister not to exercise its powers by law. And this is astonishing from the point of view of the rule of law. Imagine that the Knesset would enact a law that deals with environment or health or security. A minister that says, I don't like this law, can simply not apply or exercise its powers by this law, and the court will not be able to review this inaction. This is unthinkable from the point of view of separation of powers and the rule of law. And we had multiple petitions after the enactment of this basic law to the High Court of Justice. And for the first time in its history, we had an en banc full bench of 15 judges hearing these challenges to this basic law. And again, this is a constitutional law. This is an amendment to the basic law. And as Amichai mentioned, in this judgment that was given in January 1st, the Israeli Supreme Court, for the first time in its history, said that it has the authority to strike down not only ordinary laws, but also basic laws, if they would undermine the core values of the state as a Jewish and democratic. But moreover, a slim majority of 8 actually applied that and declared Amendment number 3 to the basic law as unconstitutional and void, unconstitutional again for violating core features of the state as a democratic one, basically undermining rule of law, separation of powers, and even competitive elections, because the core doctrine that would limit the government doing elections is derisivness. So here, by this move, and here I'm finishing, the court actually blocked the first move of this judicial overhaul, and we'll have to wait and see what would be the implications of this judgment.
Thank you very much, Yaniv. We've already received a request for your presentation to be shared with our students. I assume that would be okay with you. I don't want to put you on the spot because we didn't coordinate this before, but that would be incredibly useful. I have my own thoughts about this, both on the sort of the legal constitutional level, but I think more deeply in terms of where this leaves relations between the executive and the judiciary in Israel. Are we heading towards a potential constitutional crisis? And if so, what are the scenarios for that? But I also know that we have organized this webinar series with one of the world's preeminent experts on democracy and threats to democracy, Professor Larry Diamond. And so perhaps I will ask Professor Diamond to come in with some thoughts and questions, and then we will turn to questions from our audience. And I do want to invite our audience not to be daunted by the legalese and the technicalities of this, but to feel very free to pose questions to Professor Rosnai. But Larry, let me hand it over to you.
Well, thank you, Amichai, but most of all, thank you, Yaniv. We've been hearing, reading, absorbing, fretting over a long stream of reporting about these initiatives since they began, and you've managed to boil down the essence of what is being pushed and what is at stake in a remarkably lucid, accessible, succinct, and I think pretty non-technical presentation. So we're really in your debt. As a democracy scholar, I have the following question. some of my friends, political and social scientists and legal scholars in Israel, have been saying for years, and in fact for decades, there are probably some mutual friends and colleagues of yours, that Israel needs a written constitution. That if it had a written constitution, which is an unfinished project from the founding, really, it wouldn't have faced this existential crisis and power grab. And my question to you is that a good idea? Is that a feasible idea? And given the political polarization and the political risks in Israel, would it risk having some of the character, occasionally it's floated in the United States, of calling a constitutional convention, where if you did that in the US, you would face a high probability of opening up a can of worms where you could wind up with something drastically worse than what we have now? So could you just reflect on that as a kind of bolder possibility for democratic change in a democratic direction?
Thank you very much, Larry, for the kind words and this important question. So looking at these people, thousands of people in the street, we constitutional scholars, who study Bruce Ackerman and constitutional moments, we've thought we've been witnessing a constitutional moment. Here we have mass mobilization of people talking about constitutional politics, rights and rule of law and separation of powers and democracy, and not everyday politics of the Friday, what we call Friday Parliament in coffee shops. And I think that if there ever was an opportunity for a better constitutional settlement, this was the case. With that said, there are several problems. One, the way I see it, the Constitution is not an end by itself. It is means or aims to achieve certain ends. So if the alternative is having a bad constitution, then I prefer not having a constitution than having one. And the second problem is, if we think about a constituent assembly or a convention, then we are faced with the question, who is we the people? Who will participate in this convention? What about the Palestinians? Will they take part of it? We still don't have we don't have borders yet. How can we have a constituent assembly that would need to reflect, the constitutional identity of the people when we don't yet know who the people are? So I don't think having a constituent assembly, although there have been various voices in Israel in the last year, I don't think it's something realistic. However, what is realistic and could be similarly useful is simply to complete the project of basic laws. And we don't need much. We need to complete our Bill of Rights. It is unthinkable to me that we cannot write that all people are equal and that everyone have free speech and freedom of religion. I'm not asking for a Bill of Rights with 50 rights. Just give me those things that were acknowledged 200 years ago in the French Revolution. And we need basic law legislation that would once and for all set the rules of the game and would make a distinction between constitutional politics and everyday politics, and would make it harder to change the constitution, to change the basic laws. And once we have these two, we're almost set, we're done. If we have this regulation of the rules of the game and the relationship between the branches. So we don't need much. And I think it's important to say, and I urge all of you who are interested to Google the People's Initiative of the President of the State. There is an English version in his website. In middle of March, the President of the State proposed his own reform with basic law legislation, with a complete Bill of Rights, but with other things that the government wanted. But unfortunately, the government has rejected that proposal 7 minutes after it was proposed. And trust me, it takes longer than 7 minutes to read that proposal. So I was quite optimistic by this erosion of the public. And I think with the constitutional orientation that people now understand what are the risks, I'm quite convinced that the next government would attempt to once and for all set us to a better constitutional path.
Thank you.
Thank you, Yaniv. let me turn to some of the questions that we've received. Ray Girard, I hope I'm pronouncing that correctly, has asked, do you see a path to a constitution even over the next 2 decades? I think that sort of touches upon the points that you've already made, Yaniv, but perhaps you can elaborate. There's a discussion in Israel or a distinction that is sometimes made between a thin constitutional arrangements and a thick constitutional arrangements. Apart from the issue of a Bill of Rights and a basic law that would regulate legislation and create a clear set of rules about the status of ordinary legislation and constitutional legislation, if there's anything else that you think can be advanced even incrementally to get Israel towards a fuller constitution. You've alluded to the point that, we in a society as divided as Israel, having no fully codified constitution may not be the worst outcome that we might have. But if you would want to comment more about the prospect of reaching a more fully codified constitution, please go ahead and do that. But let me read a couple of other questions. Jeffrey Allen asks, given the continuing war against Hamas, how might Knesset legislators use the override clause to claim they should have the power to overturn the judiciary in extenuating circumstances? In other words, are there special conditions which would enable legislators to override the Supreme Court on the grounds of an ongoing national security emergency? And then a question here by Lucas Conchicao. Professor Rosnai, thank you for your presentation. My question regards your comments on finishing the Basic Laws project and the incorporation of a Bill of Rights. Isn't the political cost and foundational disagreement regarding a Bill of Rights the same that underlies the possible consolidation of a constitution? In other words, if we can't get agreement on a fully consolidated constitution, what makes us think that we would achieve agreement on a bill of rights? Lastly, here a question by Oscar Rosenblum: how would the nation-state law affect any proposed Bill of Rights? So the question of the nation-state law, which was legislated in 2018, if I remember correctly, and how might that affect a Bill of Rights? So, Yaniv, do you want to address those?
Yes, thank you. There's also another question I see about
yes,
about Lesotho, and no problem, Mukitimi, you can just Google my name and send me an email, because the question is how you can reach me or contact me. So that is easy. That's the easiest question. Okay, these are indeed challenging questions. I'll start actually with the war, because I think it's extremely important. So even though in the last year we've seen some kind of a revival of the liberal camp that has arisen against the judicial overhaul, the war makes things much more complicated, obviously, not only from security point of view, but also from constitutional points of view. Because imagine now all the various voices that talk about, for example, death penalty, or questions regarding free speech and restricting free speech during this time of emergency. Now, if the court, in a way, would protect these rights against various proposals, for example, now we have a proposal to shut down Al Jazeera in Israel, which raises issues of free speech. If the court intervenes in these decisions, then we will have again those voices that would say, okay, we need an override clause in order to bring, the final word back to the Knesset. So I think indeed, even though I thought that the override clause is off the table, and indeed at a certain point, the Prime Minister himself said he does not support the override clause, I think the override clause is still with us. especially, and this is important to mention, since we have the ultra-Orthodox proposal to free them from military service, or release them from military service. And this is a proposal that is supposed to be enacted very soon. And I suspect if the publication is correct, then this would be an extremely problematic proposal in the sense that it would violate equality in such a manner, to such a degree that the court would have no option but striking it down. And then again, the coalition would want to enact an override. So the war here is quite important. One important point that I did not mention, and I think is crucial to mention. So look at how we ended. We started last year in January, where the Ministry of Justice proposed to weaken the court. And we finished the year exactly a year later, when the court is strongest ever, because now it has also the authority to strike down basic laws. And I mentioned that because this is relevant for the judicial overhaul project. If 2 months ago, the coalition had an interest or wanted to capture the court, now, when the court has the authority also to strike down basic laws, the incentive to capture the court is much stronger than before. So I suspect that these features, the war and the decision itself regarding the reasonableness, would provide some incentives to the coalition to continue with this judicial overhaul project. About the let me maybe tackle first the nation-state law. The nation-state law that was enacted in 2018 was indeed a problematic one in the sense that it, in a way, undermined the minorities in the country. But the court, I think, managed to solve most of the difficulties in its judgment from 2021 through interpretation. And the court said that all the problematic provisions can be solved through interpretation according to the other basic laws and to the values such as equality and holistic reading of all the basic laws together. And in this sense, I don't see how the nation-state law affects any proposed Bill of Rights, because anyway, the court reads the basic law together with equality. Now, again, the question of Lucas. I don't think that an incorporation of Bill of Rights, because anyway, we have a partial Bill of Rights. So simply completing that Bill of Rights with 3 rights, equality, freedom of speech, and freedom of religion and from religion, I don't think this would undermine, I don't think it would raise similar questions such as a new constituent assembly that totally opens everything for a discussion. It is still, I totally agree, it is still problematic in the sense that some parties, political parties, object the very idea of equality. But here, some, I guess, tough compromises would have to be made. But it's still something completely different from totally opening everything in a new constituent assembly. Which brings me to Amichai's question: what else would I have done if there was now a constituent assembly, or if I could continue or complete the constitutional project? One issue that I have not mentioned, it is the completely electoral system. So the governing system in Israel is such that we have 5 politicians or 6 politicians. This is the coalition leadership, those who lead the political parties in the coalition, and they control the Knesset, and they control the government. So it is almost unthinkable, but the entire Israeli politics is led by 5 or 6 people. Now, okay, if there is one person that objects some reforms, then this person can be, the bloc in a way. However, if you have a homogeneous coalition, then you're in a problem. And I think that's one issue that must be solved together with 2 others. So we need to change the relationship between the legislator and the government. Look at the Israeli Knesset. We have 120 Knesset members, just like in New Zealand. But in New Zealand, they have 5 million people, not 10 million people in Israel. And not only that we have a very small parliament compared to other countries, but we also have a very big government or cabinet in compared to the legislature. So we have about 30 or 35 ministers and vice ministers. And if you also deduct the Speaker of the House and his deputies, and those chairs of the various parliamentary committees, and we also have a very high number of committees, we are left with about 70 or 74 Knesset members who are supposed to do all the work and jump between different committees and be both the legislators and also those supervising the government. This is unworkable. And likewise, we are lacking any sense of accountability. If there's a parliament member that does something wrong or does something bad, there is no way for him to be accountable, or for the public to say, we don't want this person as a politician, because we vote only for lists, for parties. We do not vote, like most of the countries in the OECD, for specific people. So I think the entire electoral system must be changed. If I was working, tabula rasa from scratch, these are issues that I would certainly do. The main problem that you cannot do it internally because of the agency problem. Those people who are now in politics have no incentive of changing the electoral system, either in the way I propose or to go to a more, let's say, regional way of elections, because this would undermine their powers. So we're in a big problem here.
Thank you, Yaniv. There's so much to be said about the Israeli electoral system, and perhaps that's a topic that we should return to. I completely agree. We currently have very weak mechanisms of vertical accountability between the electorate and its representatives. The entire country is a single constituency area, and just trying to think about how you would divide Israel into whatever it would be, 120 or 240 separate electoral districts is something that Israeli political scientists and constitutional lawyers have been working on for a long time. I also agree with you completely that per capita, the Knesset is just simply too small. If we compare Israel to the OECD average, the Knesset should be at least 240, 260 legislators. And let me remind you that Israel's birth rate is much, much higher than all the other OECD countries, which means that in 25 years' time, we're going to be a country of 17 or 18 million people. And the Knesset is just too small. The typical number of committees that a member of Knesset has to serve on is something like 4 or 5, which means that he or she have zero time to really hold the executive accountable. So there are a lot of really, really important issues there. I did see a question from Antonia Foray. Professor Rosnai, do you think that the international community, perhaps led by the US, has any leverage to urge the Israeli government to revisit the People's Initiative to agree on a Bill of Rights? I know what my answer would be to that. I think the answer is no, but maybe Yaniv has a somewhat more nuanced answer.
Well, as Facebook says, it's complicated. I think, look, in the previous year, foreign actors have been voicing their opinion regarding the judicial overhaul. So they were not silent, even though this was prima facie an internal domestic issue. But here, this is an important point to be made. The judicial overhaul is not entirely domestic. It also has important international consequences, particularly regarding the occupation and the occupied territories. Because one of the proposals, for example, imagine a law that was proposed and enacted in the past that allows the settlers to take private property for their own purposes. Such a law was declared as unconstitutional and void by the Israeli Supreme Court. But imagine we had the override clause, and you had a majority of 61 Knesset members still enacting it. This is no longer a purely domestic issue. This is an international issue now involving the Palestinians. So I do think that the Americans have something to say, and also think of the American Jews, because the proposed changes could also affect the ability of Jews in the US, for example, to come to Israel, or others to convert to Judaism, etc. So I think that the long-term implications of the judicial overhaul could also affect our relationship between Israel and the US. And in some aspects, it is true that Israel is not part of the EU or subordinated to the European Court of Human Rights. But if our big brother, our good friends, the US, will try to push us towards a certain move in a friendly recommendation, nothing binding, of course, I think this would have some force, at least, you know, for the politicians to understand the importance of the issue. I think it's quite important.
I would also add to Yaniv's points that the independence of the Israeli judiciary is a critical component of Israeli national security and independence and Israel's standing in the international system. And I think that the starkest example of that really has to do with the International Criminal Court and the International Court of Justice, whose own rules speak of the jurisdiction of international courts being dispositive. In other words, international tribunals and courts will step in where there is no domestic legal mechanism that has credibly investigated and punished transgressions where they need to be punished. And so the independence of the Israeli judicial system has very, very important international implications. Yaniv, do you want to add anything?
If I can, I totally agree. I totally agree. But let me add one thing that I forgot to say, and I think it's important. In the previous year, I mentioned that the government used abusive borrowing, saying, look, we simply want to be like the US, we just want to be like Canada. And here, the international involvement was extremely crucial, simply to counter these false arguments. When you had a group of Canadian jurists saying, look, what is being proposed is not like Canada at all, and we have a different system. And likewise, when you have American judges doing that, I think this carry a lot of force, or carry at least a lot of force in the debate, domestic debate.
Yeah, Yaniv, I know that you're one of the rare lawyers who is able to move comfortably from the realm of legal rules and doctrines to the realm of comparative politics and political theory. And I think that that as in the United States, as in Hungary and Poland and elsewhere, judicial politics is not just about constitutional rules and procedures. There are deeper undercurrents going on here, and maybe in the last 7 or 8 minutes that we have for this webinar, and as we said before we started the recording, we're just scratching the surface. There's so much going on here. You could talk about where you see these tensions between these different camps going over the next few months and years. You mentioned the numbers about trust and mistrust, and I think it's fair to say that in a way, one can almost tell walking down the street in Israel, just looking at people and looking at the way that they are dressed and maybe whether they have religious insignia or not, what their position on the status of the Supreme Court might be. There's a sort of a growing polarization and division where some segments of the Israeli population have a non-majoritarian view of Israeli democracy, a liberal view of Israeli democracy, and understand the importance of the separation of powers, and understand the imperative of preserving the independence of the Israeli judiciary and of the Attorney General as the main institutional check on executive power. And at the same time, there is a large and demographically growing constituency in Israel that doesn't understand democracy in those terms, that perhaps believes that the Israeli Supreme Court represents a declining elite, and that perhaps wants to see the demise of judicial independence in Israel as a realization of its own view of majoritarian democracy. Could you comment on that and just share with us how you see this contestation going forward over the coming months and years to the degree that we can foresee?
Yeah, so thanks, Amchai. These are indeed, I think, very spot on observations. I think one problem is the lack of democratic literacy in the general public. Only in the last year, I started going back and read civics books, that our kids study, and you see really horrible things. I mean, it's almost hard to imagine that this is what our kids learn when they learn civic studies. Completely distorted understanding of liberal democracy, prioritization of national elements over liberal democratic ones, really distorted stuff. So for example, just to give one example, in the page that deals with the constitutional revolution, the enactment of the basic laws on human rights, there were multiple politicians involved. You've mentioned Professor Amnon Rubinstein, the initiator of these basic laws. There was the Minister of Justice from the Likud, Dan Meridor, really prominent figure. There are other members, the chair of the Constitutional Law Committee, Uriel Lin, really important politicians. But in that book, they put a picture of a quarter of a page of one politician, Chaim Ramon, and he has a quote saying, "We've been misled in the Knesset, in the plenary session. We didn't know what we were voting for, and we were misled." But Chaim Ramon wasn't even there when they enacted that basic law. He wasn't sitting, he wasn't part of the Constitutional Committee, and he wasn't sitting at the plenary at that day. But if you're a student and you look at this page, this is the only thing you'll remember from the entire Constitutional Revolution. So for me, this is insane. So one thing we need to change is the education in the long term. Otherwise, we're doomed. It doesn't matter if we enact basic law legislation or a Bill of Rights. If the students don't learn it, then it's useless. The second problem in the long term doesn't deal with the society, but with the judiciary. We now have an extremely divided court, like the US, divided between so-called conservatives and so-called liberals. I say so-called because I don't think that judges who think, and if we go back to this judgment on the reasonness, we had a minority of two or three judges, depending on how you count, that said that even if there will be a basic law that would completely undermine the core features of the state as a democratic country, the court should not intervene. I don't think that this is a conservative understanding at all. Israel has been a Jewish and democratic country since its establishment, and preserving these features is totally conservative. Actually thinking of abandoning these values is the radical view, to my mind. So I think being a liberal, someone who wants to protect the Jewish and democratic values of the state, is totally conservative, to my mind. But we are left with a divided court, and it is extremely questionable how the court will look like in 20 or 30 years. Imagine we would have a conservative court. The importance of the Bill of Rights, the reason I mention it, because imagine we have like the Dobbs case in Israel. It is quite thinkable that in a decade, we would have a conservative court that would say, no, equality is not protected or guaranteed by the basic laws because it is not explicitly written. So we will not protect it. And this is a very high risk to my mind.
Yeah. Larry, would you like to come in on any additional points before we wrap up?
No, I think we're almost at time, Amichai.
Yeah.
The overarching point I would make that articulates with what Yaniv has been saying, going all the way back to the beginning of his presentation, is that democracy is not to be taken for granted, not in Israel, not in the United States. You know, even in a country with what is it now, roughly 75 years of liberal democracy, even a country with more than 200 years, democracy is, I think we've seen, and this goes back to your slide, Yaniv, about the gradual incremental erosion, which is a lot of what I've been writing about in the last 8 years or so. It's vulnerable. And the reason why we need constitutions, or as much of the architecture of a constitution as possible, is to provide brakes against that erosion, and brakes against the misuse of executive power. And no constitution is a guarantee, no set of basic laws is a guarantee, but they certainly are a line of defense. So I would just like to thank you personally for an incredibly important and lucid presentation.
Thank you very much, Yaniv. Over to you, and then we will wrap up. Again, there's so much more to unpack here.
I just wanted to thank you both and to just mention, because we're ending, that there are still 134 Israelis captive in Gaza. One of them is a student of ours, and I think it's important to mention them so we will not forget them.
We will not forget them, Yaniv, and we're thinking about them every single day. So thank you for that, and thank you for the work that you have done and that you continue to do on both of these dimensions: the generating institutional ideas for strengthening the guardrails to protect liberal democracy in Israel, to try to achieve broader agreement on the rules of the game, to safeguard Israel as a Jewish and democratic state in these very difficult domestic but also international times for democracy, and at the same time understanding that constitutions and institutions alone will not safeguard a free society, that it is political culture and mores and education that is essential, that we must have an informed and mobilized citizenry that will stand up and protect the rule of law and democracy now and in the future. So thank you for your activities on both of those critical levels. Professor Yaniv Roznai, Associate Professor and Vice Dean at the Harry Radziner Law School and Co-Director with our friend Liav Orgad, I should have said, at the Rubinstein Center for Constitutional Challenges at Reichman University. Thank you so much, Yaniv, for being with us. And from the Freeman Spogli Institute at Stanford, thank you and goodbye.